I'm Jim Schaefer, the producer and host of Rip Rap, the academic book television program. My guest today is James Boyd White, who's here to discuss his book, From Expectation to Experience, Essays on Law and Legal Education. I found this book fascinating, Jim, because you take a look at law not only as a set of rules and incentives designed to produce results in the material and social world, but also as an imaginative intellectual activity that has as its end the claim of meaning for human experience, individual and collective. Your definition opens up a much broader vision of the importance of law in the larger community. Would you like to comment on that?
Sure, Jim. I guess I'd like to start not so much with the larger community, but with the experience of the lawyer himself, because it is really from that perspective that the law is obviously not simply a set of self-executing rules or structures or systems. The lawyer faces a problem in the client's life to which the law speaks, but it never speaks in completely clear and coherent ways, and the lawyer has to engage in an activity which is essentially one of trying to define the meaning of what has happened in the client's life using the language of the law. So you're a lawyer on one side and I'm a lawyer on the other. What we really have is a competition before the judge or the jury as to what this story about a failed contract or an automobile accident or a dispute with a prison guard actually means. That's true at the micro level, but I think at the macro level the same thing is really true, that the law becomes a vehicle through which our society as a whole tells its story and claims meaning for it. And this is true at the grandest levels, like the framing of the Constitution, but also the decision of key cases like Brown against Board of Education or the abortion cases and things like that.
Roe versus Wade.
Roe versus Wade, right.
All that stuff that's going on. Before we go much farther, though, we ought to define some of your terms. I'm sure that's a
fair enough.
For example, the notion of education as pointing toward a process. This one being the way we constantly modify, as you say, our expectations based on experience. And in this usage, education is not restricted to a series of formal classroom training sessions, but an ongoing reflection and involvement that's much more fluid and has greater depth.
Right, right. This is really, in a way, the center of what I do in this book. And it involves the conception of a certain conception of human life as itself educative, and education not as it's usually talked about as the acquisition of knowledge or the learning of skills or something like that, but as the essential process by which an individual engages with the world. And as I say, and the title implies, this has two dimensions, sort of systolic and diastolic in character. I think that at every stage of life, what we're doing is constantly using our prior experience to form expectations for the future, which are the best we can do, but the expectations never work out as simply and clearly as we imagine they will. Experience always complicates our expectations, and this means that we have to adjust to that disappointment or surprise or whatever it is. This leaves us in a somewhat different position, having trained somewhat our capacity for forming expectations in an increasingly realistic way. And I think this is really true of all education. I mean, I think this is how language is learned as a little child, how you learn mathematics, how kids learn how to negotiate the playground, how grown-ups learn to serve in the army, and how a society structures itself is through the casting forth of expectations which reflect a desire for coherent and meaningful experience, which are, in the nature of things, going to be at least complicated by experience. And then you have to adjust to that, then form new ones, and so forth.
And of course, one of the things that is important here is that you are a professor in the law school at the University of Michigan. And so talking about education of the law students is you bring in an additional dimension to that, you know, as you reflect in this book.
Right, right. That is, I mean, I'll give you an example of how, of modifying your expectations by experience is what happens with a typical kid when he comes to law school is he or she thinks that what he's going to learn is a set of rules, and he'll know the rules, and he'll go out in the world, and other people won't know the rules. He will, and they'll pay him for telling him what the rules are, and it's as easy as that. In fact, of course, what they find is that many of the rules have to be inferred from other materials. They're not clearly stated. And even when they are clearly stated, they require interpretation in particular cases, and they're always highly arguable. So the process of lawyering, as the student begins to learn it, is not just a question of looking up rules in the book and then applying them to clear facts. In fact, that's almost really a tiny part of what we do. Instead, it involves the most difficult thought about what would motivate or should be taken to have motivated the people who decided this case or drafted this contract or wrote these statutes and the like. In other words, it's really hard. And this is
more than just looking up case law. And
absolutely, absolutely. It's thinking about if you're a lawyer, with a case, and in law school we simulate this by asking students to think about cases one at a time. What you think about is what this case should be taken to mean in the light of all of the potentially relevant legal materials, and in light of the fact that there are two sides to this case, with lawyers on both sides, and each is going to be trying to claim that these materials should have a meaning that's favorable to their client. And this is a way of really forcing the student to work with a kind of unexpected energy and intensity on these materials.
And that's where this element that you're talking about, language, it helps the students and others work with some precision as far as understanding meaning and intent.
Well, that's really right. The one way you could put this point is that if you go back to the image of the law that the student brings to law school that I was giving before, this is actually a perfectly sensible one based upon the student's prior experience, which is maybe an example of this would be he moves to a new state, says, I got to get a car license. How do I get a car license? You look up the rules, you go get a car license. It's all perfectly manageable and bureaucratic. Well, that's how law and bureaucracy works when it's not problematic. But as soon as a problem arises, somebody really wants something and somebody else really wants something else, and they're both invoking the law, and suddenly then the question of the meaning of these rules or judicial opinions or regulations or contracts, whatever the legal texts are, becomes prominent and salient. And the question of precision and intelligence in interpreting that language becomes the great question for the student.
I found it interesting that you encourage the students to take a look at imaginative literature, because you don't normally think of that. You think mostly of attorneys in training, of looking at case law, but you encourage them to look at imaginative literature. Yes,
and this is actually a way, if I can return to this theme, of modifying their expectations. Again, the idea that you might have, which the law is simply the application of rules or simply policy working out through bureaucratic systems, isn't adequate to the experience of the lawyer or judge faced with a real case. And one way to put it is to say that what the lawyer or judge faces is the following situation every time. How do I use and understand this language of the law that I've been given to use? And how do I establish functioning relations with the people I'm speaking to, whether it's a jury or a judge or it's two lawyers drafting a contract? The general question is, how does the mind relate to the materials of the culture, and what kind of community or set of relations does the person constitute when he speaks? Well, these are crucial questions for the lawyer. We normally don't think about them that way. It's only when you imagine the lawyer or recognize that the lawyer is an expressing person in a cultural and social context that you do this. And here, imaginative literature is completely relevant, because we have, in the world of drama and novels and so forth, people who are engaging in exactly this double relationship, using and transforming their language, creating relations with others. That is the center of what the lawyer does as a speaker or writer as well.
And regarding or taking into account the reader, which would function somewhat like the jury or
Right.
it's the audience, of how you present what you're doing and understanding that part of it. It's always been fascinating to me that the study that the attorney has got to do in preparing for a case, not only in terms of the case law, but also in terms of the jury that he or she is faced with. That there's this relationship that's developed there.
Right. And it's not just the jury. It's the jury, the judge, the lawyer on the other side, the witnesses. Every single time that the lawyer speaks, as when you and I are speaking right now, one thing we're doing is creating a relationship with each other as we talk. The lawyer creates a relationship, or tries to. And the question that the lawyer ought to be asking is, what kind of relationship do I want to establish with this witness or this client or this lawyer, and how can I do it? And this is a whole dimension of expressive activity, which is often just simply not regarded.
And I would think, too, by taking a look at imaginative literature would encourage people to hone their skills at analysis and of sizing up, I guess, the character of the people that they're dealing
Right.
with in all those different ways you're mentioning.
Right. That's exactly right. I mean, one way to look at the imaginative literature is that these are people who do what lawyers do and all of us do whenever we speak, but do it, the good ones, extraordinarily well. So we really ought to be able to learn a lot from their examples about how to use and criticize language and how to establish relations with others, both themes.
We can't talk about law in this country without touching on it, as you indicate by the title of your first chapter, The Rhythms of Hope and
Right.
Disappointment. In the legal profession over the years, as it's struggled with the complexities of social and historical change and with the process of training law students properly. Maybe you can comment on that. So.
Yes. Well, there are a couple of different ways in which that I can comment on that. One of them is that it's part of the actual life of the law that it changes. So you have a body of law, developing a body of doctrine or a series of cases or something which do the best that the decision makers can do with their problems at that moment. Culture changes. Things shift. And the question is, how can the law recast the expectations that they have in light of new experience? And the most dramatic instances of this are the great cases which overrule prior cases like Brown against Board of Education, or which establish a new right like Roe against Wade, as you were saying earlier, and so forth. There's also another dimension to it, which is that in our culture, there's always a question of what expectations the public have about the law. And these are often unrealistic and have to be modified by the process of history, as we see that something that we thought would work didn't work. An example of this, which is in which both the public and the legal profession really have had to come to terms with things, is Brown against Board of Education itself, which, when it was decided, I can even remember this, was thought to promise really the end of racial hatred and separation and the introduction of a new era of brotherhood, that within a generation this problem would be gone. And it's obvious by the Supreme Court's own experience in deciding the cases after that, and in questions like affirmative action today, that these are still enormously intractable problems for our society and for the law that haven't been solved by
Yeah, there's several major issues that seem to have been shifting back and forth: abortion rights and all of those affirmative action, euthanasia, been struggling
death
with
penalty
it.
would be the same kind
Death penalty, capital punishment.
Right. These particular ones are all instances where in our culture, rather oddly, we look to the law and the courts in particular as the forum in which the most fundamentally divisive social issues will be resolved. Most countries don't do that. They do it through the political process or legislation or something. But We think of these as constitutional questions.
And there's some people, like, was it Judge Bork, that thinks that there ought to be less involvement by the Supreme Court in deciding things. I found it interesting in this book you not only discuss the various forms and genres of legal writing, law schools, judicial opinions, legal critics, and scholars, but the imaginative literature, as we just talked about, is a way of extending the dimension of thought and feeling and complexity of legal scholars. Even more interesting is your portrayal of the lawyer as an artist with language and thought, who's concerned with the ethical and linguistic plane where we remake in our text both our languages and ourselves. But this point is even extended in a later chapter on meaning in the humanities and law. In other chapters, we discuss specific legal contexts like the corporation and the economic model of wealth, religion, and the underlying assumptions in modern discourse, and abortion litigation. And this idea of is for lawyers not being the judicial rule, but how a case should be decided in terms of the credibility of the authorities cited and their judgments on the issue at hand.
Right.
That's quite a chunk of material.
Well, yeah, there's a lot of thoughts in that one statement of yours, Jim. Let me begin with the end, which is what's involved in a judicial, as you put it, how a case, not the judicial rule, but how a case should be decided. The one way to put this point is the following. An essential part of a lawyer's education is the constantly deepening discovery that every case has two sides, and however clear your own view is about the constitutionality of abortion or the death penalty or affirmative action or whatever the big issue is of the day, or big issue for you, you recognize that in our culture, really cogent and coherent arguments can be marshaled on the other side. These are matters which, this is what it means to say these divide us, is that there are really two sides to these questions. And the law, in a way, is a way of recognizing and dealing with and responding to that fact. And the way this connects with your observation you made is that one of the things I suggest here is that there are two different ways of evaluating what a court does. And one is in terms of its outcome or rule. You say, I disagree with where they came out on abortion, or I agree with it, and here's why, and so it agrees with me, so it's great. The other is to acknowledge the possibility that it may be a good judicial opinion, even if it comes out the other way than you want, or it may be a bad one, even though it comes out your way. And so in this sense, what you're doing is evaluating in a more neutral way, or professional way, the excellence of mind and character that you hope for and expect for from a judge. And part of my effort in this book is to try to give an example of that with respect to the abortion decision, Planned Parenthood against Casey, which is, as I say here, attacked from the right because they reaffirm the core of Roe against Wade, attacked from the left because they don't affirm all of Roe against Wade. But I think it's really quite an admirable decision from an ethical and professional point of view because of the way in which the writers of the plurality opinion marshal and organize the authoritative materials of the past in a way in which they actually respect them as a source of authority and law, yet at the same time are present themselves as minds making a decision. It's really quite an extraordinary job, I think.
Well, we're not talking about dusty issues. These are issues where people are blowing up places and are picketing, and there's some real battles, literally, over what should happen, and there's a serious social issue that one hopes the civility of the moment of being able to argue this, and I mean argue in the argumentation sense of presenting the sides, that we'd be able to work this out in a civil manner rather than some of the other options. But it's very serious. And I think that also points toward the value of the legal profession, is that we can take some of these issues and present them and hopefully resolve them and have people abide by them rather than try to enact them on the street.
Right. Right. That's exactly right. I mean, there is a tendency among some people to think that the law is nothing but power or nothing but politics. And there's no difference between, and the only thing in selecting a Supreme Court justice is he a right-winger or a left-winger, share my views or not share my views, because all he's going to do is act out of his or her pre-existing political commitments without modification as a justice. I think that's wrong both descriptively and normatively. Obviously the judges have values, and they should, in fact, function out of them. On the other hand, the process of thought and argument, when they confront a problem and confront the authoritative materials of the past, which is their obligation to interpret in that problem, should modify, change, and enrich their own minds and their performances. And the net result is, if it works, that the law becomes not a completely independent or completely autonomous, of course not, but a field of culture and authority in its own right, through which the most divisive issues on which we in fact do divide can be resolved in an orderly, imaginative, basically fair way without being reduced to merely political disputes over political will and desire.
I want to go back to that example you're using of the law student, and maybe it's looking at the pinnacle of success in the legal professions, the difference between a politician and a statesman as being
Right.
an attorney and a scholar, or a legal scholar, in the sense of respecting the profession and its obligations to look at, and develop a position independently based on the literature, the legal citations, and one's own search for the facts in the case and reflecting on it. It would seem to me that would be this higher calling, and then
Absolutely right. If you go back to the issue of the kind of expectations students have when they come to law school and what we try to instill in them, and what we do try to instill is a sense of possibility in their profession and challenge that, and it's not just in big cases. A small case, financially small case, is still important to a client. There's still the questions of how the facts are to be understood and the story told. There's still the question about how the contract or the regulation of the statute or the other case is to be interpreted. There's still a question of what kind of meaning the case is to be given by the lawyer. And that is a challenge to the imagination and the whole mind of the lawyer. That's one of the things which makes the profession worth practicing, worth teaching, and worth having.
And throughout, the decisions that made them become case law along the way of
Right.
varying significances. But
Right. Right. It's a system which is always in the process of changing. So whatever resolution the law makes at one particular moment, and you may argue about it for months before they finally do it, and they come to a resolution, here's how we're deciding the abortion case or something like that. The minute it's decided, it becomes part of the past, part of a larger cultural context, and it's going to need to be interpreted in the light of the larger cultural context of which it's a part, as well as changing events in the future.
in your chapter on teaching law and literature, I found your discussion of your book, Justice's Translation, to be fascinating, especially the comment that if languages cannot be collapsed into each other, it means that no one language can claim priority over others, and even that no one statement in any language can claim to be universally true. So it points up again this need to sift through and be careful about.
Right. Something else that means is that excuse me, is that it's not possible in the law or anywhere else, as far as I'm concerned, but for present purposes in the law, it's not possible to say now, this is the truth for now and for all. Instead, every single time that the question arises, it's going to be rethought about, reformulated, retested, and every speaker has the obligation not simply to invoke in a dead way some authoritarian phrase from the law or from somewhere else, but has to assume the responsibility for making a really meaningful statement about the case or problem that's before him at the time, recognizing that his statement, like all statements, will be incompletely understood by others, and insofar as it's a representation of other views, it too is an imperfect representation. We just live in a world of imperfect imperfect statements, imperfect readings, and that's one of the things which makes it
It's a
interesting.
key concept of meaning, and whether the person who heard or reads what you say understands what your intent was as you said it, and also is able to interpret the terms you used in the same context or purpose that you intended to have them stated.
Well, you know, it's, as I was just saying, that never happens perfectly. You and I are conversing and we're understanding each other pretty well, as people do, but there were laws that the more we did it, we'd realize, and the more intense the conversation got, we'd realize that there were spots of misunderstanding and incomprehension both ways. That's a feature of all human life. So the effort to make yourself intelligible to another is always an effort to bridge a gap which can at best be imperfectly bridged. So you try and say something which is really useful to the other person, but won't completely communicate your idea to them, because that can never happen.
Along with that, we ought to talk about the notion of civility, or the life of civic responsibility and action for those involved with the law and all people, and the idea that we belong to a larger community and have a place within it as a participant and not merely an observer. And this, of course, addresses your point that excellence of judgment is the work of the whole mind, including the affections, including the capacities to suspend conclusion.
Yes, one of the deep themes that runs right through this work is the idea of whole-mindedness. And in a sense, you can say that as a teacher, what we try to do is to encourage our students not to think merely as technicians, not merely to think as figures in a bureaucratic structure, but to think as whole-mindedly as they possibly can about the question in front of them. And all the questions in front of them, including the questions about their client's life and story, but also the questions about the law and its meaning, and also the questions about what the law ought to be. But the deepest thought has to be whole-minded. And it is the whole-mindedness, when it can be achieved, or to the extent it can be achieved, which makes it clear that the lawyer or judge is actually part of the larger community and not completely separated in some bureaucratic or official or highly professional way.
Well, it's a very interesting book, and I think it speaks to the larger community about the law, as well as speaking to others within the legal profession, both teaching and learning it and judging it. Thank you for being on Rip Rap.
Well, thank you, Jim. It's been a great pleasure.